Caleb, I know that landlord-tenant law is Florida Statute 83. That may be the only chapter number I've ever memorized in my legal career because I used it so much as a younger lawyer. But Chapter 83 is broken up into two parts, Part 1, Part 2. Part 2 is strictly residential.
That's correct.
Part 1 is strictly commercial.
Correct.
For residential, when it says if your tenant is not paid rent, step number 1 always is a 3-day notice to pay rent or vacate. What is step number 1 when you have a commercial tenant that's not paid rent?
It is the same step.
And same form, same 3 days to get them to pay, and et cetera.
Yes.
And so when it comes to evicting a commercial tenant, where are the differences between evicting a commercial tenant and a residential tenant?
Well, in a commercial setting, there's a lot of remedies for the landlord that don't exist in the residential setting. For instance, one of them is you can lien the property of the commercial tenant if you do, a correct complaint to do so. If there's unpaid rent and you file a specific type of complaint to lien the personal property, at the end of that action, you're going to get to lien, sell, and make yourself whole for the unpaid rent through the use of the tenant's personal property. That really does not exist in the residential setting.
Yeah, in the residential, when you evict a residential tenant, the Florida statutes are trying to make every opportunity to make you and allow the tenant to take the tenant's stuff with them.
Correct.
In a commercial lease, I think there are times where you can actually have the locks changed while the commercial tenant's inventory is still in the rented space for the purposes of, okay, as a landlord, I'm going to be holding on to this stuff and I may be trying to sell it to recoup the money that's owed me.
That's right. You just have to, get an attorney before you do that because you have to make sure you file the correct type of complaint to do that, but that is absolutely a possibility.
And I would think it might be a likely possibility because, to evict a residential tenant, the initial summons is a 5-day summons. Is
Correct.
it a commercial? Is it a 5-day summons?
Yes.
And so then in a pretty quick process, you can get a writ for possession, take possession of the commercial space, change the locks, and now the tenant stuff is all locked in there, and the landlord might very well have a lien against it.
That's right.
All right, I'd like to talk about that in some more detail. Hey, folks, Caleb, I want to talk about this issue that you own a commercial building, you have a commercial lease with somebody, they are failing to make payments. Well, of course you want to evict them for non-payment of rent, but wait, let's talk about the contents of the building that the tenant has in there. Can you as a landlord somehow claim ownership of those things? And Caleb, I want to specifically talk about a case that I remember maybe way back from law school, and that is that the tenant was in the business of selling used pianos, so that the commercial space had a bunch of used pianos in it that, they've got some value to them. And tell you one thing, if you're in a used piano business, you can't move those out the door real quick once you start getting evicted.
No, you can't.
So sure enough, the landlord took it back, went through the process. And so in that situation, can the landlord, one way or another, claim ownership of the tenant's inventory of used pianos?
Yeah, so a landlord will have a lien. So the first thing to note is the statute gives a landlord a lien over all tenants' personal property for unpaid sums. Now, the question is, how do you execute on that lien? You have to file a distress for rent complaint, and you're asking the court to issue a distress writ. What this writ does is it prevents the tenant from taking those pianos out of the unit. That way you don't lose your ability to lien those things. So that's step number 1. You get this writ from the judge. You're going to have to post a bond, which is double the value of the property that you have a lien over. That's what the landlord's going to have to do. You're going to have to post that bond. You're going to get this writ, and now you have the security of all these pianos in there. If the tenant removes them, they will be in contempt of court. The second thing that's going to be determined is whether this distress writ is valid or not. So the defendant may go to the judge and say, hey, this is no good. And the judge is going to make a decision. Hey, can the landlord levy on these things or not? A lot of times if there's unpaid rent, the answer is going to be yes. Great. Now you go and you have to actually auction these things off to sell them, basically foreclose on them, and you have to publish this sale in a newspaper at least twice, and the first one needs to be at least 10 days before the actual sale. Make yourself whole for the rent by selling these pianos.
And I suppose if there's any money left over from the sale, that would belong to the tenant.
Absolutely.
Now, why do I remember that case? Because, as I recall the case went, there was a John Q. Public, somebody out there, that said, hey, I'm going to put my piano out of my home. I'm going to put it on in your store. I'm going to have you sell it for me on consignment. So, tenant, when you sell this piano that's my piano, you're going to take a piece of it and you're going to turn around and give me the cash. And then sure enough, the landlord did this distress for rent. And so the issue was, okay, did this piano that was on consignment in the tenant's store, did it belong to the tenant or did it belong to John Q. Public? And I remember how that case shook out. If you don't.
Yeah. I don't remember. Let me know.
Well, the way it shook out was the judge ruled was this, is that there was nothing on that piano, no tag that says this is on consignment. If there had been a slip of paper, a little piece of string and a slip of paper that says this piano belongs to John Q. Public, it's on consignment, John Q. Public would have gotten it back. But there was nothing on the piano, no slip of paper, no piece of tape, no nothing that identified it to John Q. Public.
Wow, and it is important to remember that the statutes do allow third parties to come in when a distress rent is filed and, for instance, say, that's mine, it's on consignment. They can interject and stop the landlord from doing what they're doing, just like you said, but it sounds like they need a little tag on those consignment property.
So if you're consigning your piano, be forewarned. Get out a piece of tape and surreptitiously stick it under the piano somewhere and says this piano belongs to John Q. Public. If found, return to me.
Oh man. Well, the other thing to remember, if you're the tenant, you always have the right of, I'll call it a right of reinstatement, but really you have the right to post a bond in double the amount of the value of your property, and you could take your property out even after that writ is issued by the court, because then the landlord
Yeah.
can go after that bond.
Well, let's talk about something kind of different along